Okay, let's dive into this. Welcome to This Explainer. Today, we're dissecting a really fascinating anonymous expert report that lifts the hood on the hidden mechanics of administrative courts. We're going to look way past the surface level narratives here to understand the actual cause and effect mechanisms governing these incredibly complex legal proceedings. We'll treat the source material like an objective blueprint, breaking down exactly how a massive, somewhat overwhelming bureaucratic apparatus actually tries to maintain the integrity of its own due process. So grab a coffee and let's get into it.
You know, the underlying thesis of this expert report rests on a very clear implicit assumption. Facing a government prosecuting attorney entirely on your own is a fundamentally overwhelming experience. But here's the thing, the system isn't actually designed to just blindly crush the unrepresented. Far from it. Instead, as the report reveals, there's a really complex structural safety net deliberately built right into the legal architecture, and this net is designed to prevent systemic due process failures. If a defendant actually understands these mechanisms, what initially looks like an impossible scenario transforms into a navigative, albeit pretty rigorous, procedural pathway.
Let's move to our agenda and see how this all builds. We'll be looking at the systemic safety net, language and communication mechanisms, leveraging time extensions, free legal assistance lists, forms and evidentiary support, and finally, informational and logistical tracking.
Starting off with Section 1, the systemic safety net balancing the scales of due process.
We aren't just going to look at this procedurally from the minute a defendant walks into the courtroom. Instead, we're categorizing these resources by their functional mechanism. To really grasp the baseline reality of the unrepresented defendant, we have to ask ourselves, how exactly does a highly complex legal system accommodate an individual with zero formal legal training? We've got to pivot away from just saying, well, the law is hard, and instead analyze the specific, mandatory accommodations. When a defendant lacks representation, it actually triggers a forced structural response from the court itself. We're hunting for those precise cause and effect relationships where the court is literally forced to bear structural obligations to make sure the scales of due process don't completely tip over.
Notice the stark institutional contrast here when we look at these obligations. On one hand, the court is legally burdened with explaining the initial charging document to the defendant, making absolutely sure they understand the complex allegations brought against them. But on the flip side, the defendant's responsibilities are rigidly strict. According to the expert findings, defendants must independently secure and submit certified English translations of all foreign language evidence. Think about how much work that is. Furthermore, they're bound by a highly unforgiving 5-day window to update the court if their address changes. Just 5 days. So the court provides legal clarity, but the defendant carries a massive logistical burden to stay in the game.
Let's move on to Section 2, language and communication mechanisms and the crucial role of interpretation.
So here's the deal. Without guaranteed language access, the entire concept of a fair hearing just instantly collapses. It's really the most fundamental safeguard in this whole administrative framework. The crucial point here is that the system completely assumes the financial and logistical burden of this communication. It is entirely at the government's expense. The report notes this fascinating procedural absolute. The court actually has to figure out the defendant's absolute best language or dialect. And get this, if an interpreter for that exact dialect isn't immediately available, the hearing simply cannot proceed. The court is structurally mandated to hit pause and reschedule the whole thing until proper translation can be secured. Accuracy and actual comprehension are prioritized over just pushing things through quickly. This direct quote from the expert report really nails the concept down. The interpreter will be provided and paid for by the government. You do not have to provide your own interpreter. Analytically speaking, this is incredibly significant. This isn't just a courtesy extended by a nice judge, it is a rigid, structural mechanism. Without this mechanism actively functioning, the legal validity of the entire proceeding is totally compromised.
Moving right along to Section 3, leveraging procedural time extensions and using time as an actionable resource.
In these initial procedural hearings, which are often called master calendar hearings, we see how time itself is systematically converted into a literal resource. Now, standard bureaucratic procedures usually want to rush people through, right? But here, the procedural timeline is explicitly designed to prevent railroading. The system actually encourages a bit of delay at this stage. According to the report, the court is generally required to wait at least 10 days after serving the initial charging document before holding that very first hearing. This mandatory waiting period has a specific functional purpose: to give the defendant actual time to secure counsel. Plus, as we see here, a self-represented defendant can actively request further extensions of time to find an attorney or prep their case. The system actively accommodates the delay to ensure real preparation is actually possible.
That brings us to Section 4, Free Legal Assistance Lists and Navigating Representation.
Next up, we're analyzing the systemic approach to representation itself. Now, while the government won't pay for your attorney, the court is absolutely mandated to provide tools to help you find one. And this brilliantly illustrates the system's attempt at quality control and fraud prevention. The court provides a localized, official list of pro bono or free legal service providers as a systemic shield against predatory fraud. This fully vetted list of licensed attorneys and accredited representatives is a direct cause and effect tool deployed to safely reduce the unrepresented population. The report heavily contrasts these regulated professionals with totally unregulated actors. You might hear them called consultants or notarios. These are people who make false guarantees, they absolutely cannot legally give advice, and they can't even appear in court with you. Relying on them is a massive risk that the system actively tries to steer you away from.
Okay, Section 5, Forms and Evidentiary Support. Procedural guidance from the bench.
Now we're entering the phase of the individual merit hearing. This is the actual evidentiary trial where the core arguments are made and the line between a judge and an advocate becomes highly critical. The expert data delineates strict boundaries of rights and obligations during this specific phase. The defendant has the right to examine all the government's evidence, cross-examine opposing witnesses, and present their own corroborating documents. However, this comes with some very rigid procedural deadlines. For instance, evidence usually has to be submitted 15 days prior to the hearing, no exceptions. And the defendant absolutely must submit to mandatory background checks before any legal relief can be granted. The judge, for their part, must provide blank applications and instructions, but they face a really strict limitation. They absolutely cannot offer legal advice on how to actually fill them out.
Think about the highly nuanced role this creates for the judge when dealing with a self-represented individual. I mean, they are the ultimate decider of fact, right? They assess the credibility of the defendant's testimony, but they also have to serve as procedural guides. How does that balance actually work in practice? Well, a defendant might speak incredibly credibly, but the judge may still require specific, hard corroborating evidence to meet that rigid legal burden of proof. The judge guides the procedure, making absolutely sure you understand your burden, but at the end of the day, the defendant alone carries the weight of proving the facts.
And finally, Section 6, Informational and Logistical Tracking, the mechanics of compliance.
These tracking mechanisms are basically strict informational tethers, keeping the defendant bound to the administrative system. Now, what's really interesting here is the severe, almost automated cause and effect mechanism attached to something as simple as a change of address form. If a defendant updates their address, they receive their notices and their procedural rights are preserved. But if they fail to update that address, the consequences are honestly devastating. It leads to missed notices, which immediately triggers an automatic negative judgment, an order of removal in absentia. Furthermore, the experts note this single failure can result in a massive 10-year bar on accessing certain forms of legal relief. The administrative machinery simply does not forgive logistical errors. It's brutal, but it's the reality.
But to help prevent those kinds of catastrophic errors, the system utilizes specific tracking tools. The report highlights that every single defendant is assigned a unique 9-digit identification number. This number is literally the vital key.
With it, the self-represented defendant can access 24/7 automated national phone lines and online court portals. These tools allow the individual to independently verify their hearing dates, track case statuses, and ensure they remain in absolute strict compliance with the court's calendar. It essentially allows them to bypass the need for a lawyer just to check a schedule. It democratizes logistical access, placing the power of procedural tracking directly into the defendant's own hands.
So, as we wrap up this explainer, we are left to consider this final, provocative thought. How do these systemic resources fundamentally alter the balance of power in an administrative court setting? We've seen exactly how a seemingly overwhelming government apparatus actually deliberately embeds strict safety nets, everything from mandatory interpreters to pro bono lists and rigid procedural pauses, specifically to maintain the integrity of its own legal process. It really leaves us wondering, when an individual completely masters these systemic safeguards, how much power do they truly reclaim from the system? Thank you so much for joining me for this explainer, and keep questioning the hidden mechanics of the systems around you.